Secretary Napolitano, please call the roll.
Student Trustee Rourke.
Yes.
Trustee Bernstein.
Yes.
Trustee Mazzocchi.
Yes.
Trustee McGuire.
No.
Trustee Napolitano is yes. Trustee Olson.
Yes.
Trustee Wozniak.
No.
Motion passes. Agenda item 14. Tonight is the second reading of amendments to Board Policy Number 5-180. And I will entertain a motion that the Board of Trustees approves the amendments to Board Policy Number 5-180.
So moved.
Moved by Secretary Napolitano,
Second.
seconded by Trustee Bernstein. Any discussion? Trustee Olson?
I wanted to discuss this item. Obviously, I understand it's a late hour, so it's just perhaps maybe would be more appropriate to discuss it at a time when it's not so late. But depending on the item I really wanted to raise and discuss was this item 3 in the proposed amendment. It's the third bullet point. It says no less than twice a month, council shall provide a written update to the board regarding the status of any matters pending before courts or administrative agencies, which I do appreciate, and I think the idea of these law firms providing written reports to the trustees of the status of these lawsuits and the status of their engagements with the college is something that I would find desirable. I believe that it's important that the trustees have information about what's going on, and it's also much easier if there's a written report for us to distill and understand and formulate questions so that before we go into a closed session or before we contact attorneys, we know what questions to ask. So I appreciate this. However, my question was with regard, and perhaps this is somewhat regarding my newness on the board, the twice a month figure. And what I'm concerned about is one of the concerns that's been raised has been the legal billing. And there's a lot of legal fees, and I'm very interested in ways that we can minimize this cost to the college. Given that this board in its regular form is supposed to meet monthly, would it make more sense to have these written updates provided on a monthly basis? Obviously, to be honest, I would prefer to receive them twice a month. However, I'm just thinking about the cost that these law firms will incur and then bill the college for with regard to writing a memo twice a month rather than once a month. So I just wanted to throw that out there for my fellow trustees for discussion.
Okay. Does anyone have any comment on that? Trustee McGuire?
Okay, this policy, it first showed up on November 5th. I spoke against it that night, and I'm still against it. And it had its origins with an invoice from Mr. Kinsella's firm on August 6th. Shortly after Trustee Burt and I filed our FOIA request and later a client demand letter with all 3 attorneys regarding the 5 months we endured without legal or financial information necessary to perform our due diligence as trustees. It was on August 6th that I saw the Dan Kinsella invoice with the following notation. Research regarding...
Trustee McGuire, you can't release...
It's about dissemination. This is not privileged information. This is not privileged.
Can you
I can definitely say this.
Can you show the invoice to Mr. Elliott?
The invoice I'm referring is the one I just referred to in closed session.
Can you just show, whatever it is you want to read, can you just show it to Mr. Elliott first?
I think I know what it is, and
It's the privileged information.
The position that we've taken is that and I think we've taken it consistently when in releasing documents. After the ray line, the subject matter of the research is considered by the college to be privileged. So I do understand there's an entry that you have regarding research that related generally to your information request. I think going beyond that would release privileged information.
That's not what I'm talking about. I'm talking about the one that mentions the trustee control group.
Okay.
And that is not privileged.
No, to the extent you're going to talk about an issue that relates to...
this policy right here.
No, To the extent you want to get into what one of our attorneys has been researching in terms of subject matter in connection with providing the board with legal advice, that's not appropriate to release because that's privileged information and it would require a full board vote to, or a majority board vote to release. That being said, if you want to just say, I understand Mr. Kinsella has done research and not reveal the subject matter of the research, that's okay.
Well, it doesn't accomplish my goal. But I'm going to say that if this policy had been in place on December 15th, Trustee Burt and I would not have had access to these documents. And I'm going to tell you right now, this is $1,239,160 in legal invoices. That's what it looks like. And on that morning, I think it was 11 o'clock when we came over, or something like that, we were expected to stay in that room and go through all of that. This was 11 hours of research for me. That could not have been accomplished that day in the finance office. This policy is going to indeed allow, with number 5, the board may in its discretion direct counsel to disseminate such materials to an individual trustee with or without conditions designed to maintain confidentiality. And in our case that day, it was John Dishner was in the room, and he was to stay there the whole time we looked at all of these documents. At $685 an hour, that was his job that day, to watch us look through all of this. This policy is going to make that much easier. We would not have been able to take these home. I would not have been able to study them like I did. I know these documents. I would not have known them otherwise.
Madam
Trustee,
Chairman,
Trustee McGuire, I just want to say that that's actually not, that's not a true statement in that you and Trustee Burt were, again, you were both given the offer of taking controlled copies that would have your name on them or a unique identifying number on them, and that request was rejected. And you were also offered to have delivered to you copies of the documents electronically that would then be secured through password protection, and that was denied. So I want to be clear, you weren't being denied access to documents. What we simply wanted to ensure is that we were taking affirmative steps to preserve and protect the privileged nature of the documents and the confidential nature of the documents.
And these documents have been protected, and we should have been trusted as trustees.
Well, and the concern, of course, as you well know, is that many of the college's privileged documents have made their way into press, have been...
Not from this trustee.
Well, the fact of the matter is that we know that that has occurred, so all trustees need to be obligated to maintain things as confidential, and we as a board need to take affirmative steps to ensure we're protecting confidentiality that's applicable to all trustees. And as I mentioned to you, to the extent I've had to review legal bills.
That's not what number 5 says, does it?
No, it does actually, because
No, it doesn't.
item number 5 allows the board, so that's the board, to either disseminate the materials to an individual trustees with or without conditions designed to maintain confidentiality. The problem was you were unwilling to take the documents under conditions designed to maintain confidentiality.
You really had no authority to tell us that, and you know that. It was
No.
a 3-3 split. You didn't have the authority to tell us to take these in any other way. We had no policy in place. You exceeded your authority that afternoon, and it was unacceptable. These documents belonged with the trustees on this board.
Trustee McGuire, I would take the position that you do not have the authority to waive confidentiality.
No one's waiving it.
Put in place.
I am definitely studying.
But you declined to accept
That's
very simple measures.
That is not the
designed
same
to-
as a waiver of confidentiality, not to accept
Chair-
your conditions.
Chair Mizaki?
Sure.
May I respond to, if possible, to Trustee Olson's concern?
Sure.
In recent months, the board has been meeting twice a month. I think it's, my understanding is it's the aim of everyone to go back to once a month. The concern I have is that in some of these cases, a month time is a lifetime. And so if we're going to be providing, somewhat, reasonably timely guidance to trustees on what's going on cases, I think every 2 weeks is appropriate. With respect to your concern about, the fees associated with it, the fees on this are actually pretty minimal. I don't know if you've seen the form report that we use, but, it's really just going through the cases and adding perhaps changing a sentence or two or tweaking, the latest developments line in each of the matters if there have been changes. So it's no great undertaking, but I do think that getting something to the board more frequently than once a month is important.
Thank you. I appreciate that additional context. It's helpful.
Does anyone have any other discussion?
No.
Okay. In response to the prior reading of the policy, it was proposed to add some interpretive notes, and I think those interpretive notes actually get to some of the issues that Trustee McGuire was raised in the sense of what does it mean to talk about conditions relating to confidentiality. And I'd like to propose adding this amendment to the policy that says interpretive notes. So this is the motion that I'm making, to add to the end of the policy interpretive notes. In making determinations under 5 above, the board may consider factors such as A, whether the request is proportional and/or germane to the individual trustee and/or board's oversight interests. B, whether the request for copies of privileged documents outweighs the burden or expense of the request. C, whether less burdensome or costly means, including e.g. discussions in closed session or document review under controlled conditions, exist to provide the requested information. D, the nature and timing of the request, and/or E, the nature of the requested information and the risks posed by the public release of such information. This list is not intended to be exhaustive. Is there a second to that motion to add the interpretive notes?
Second.
Seconded by Trustee Napolitano. Any discussion on the interpretive notes? Hearing none. Secretary Napolitano, would you please call the roll on the amendment to add the interpretive notes?
Student Trustee Rourke,
Yes.
Trustee Mazzocchi,
Yes.
Trustee McGuire,
No.
Trustee Napolitano is yes, Trustee Olson,
Yes.
Trustee Wozniak,
No.
Trustee Bernstein.
Yes.
Motion passes. Is there any further discussion on the policy itself?
Trustee Mazzocchi.
Trustee Olson?
Just apologies for the additional discussion. I appreciate Attorney Elliott discussion about my question on point number 3. I think, from my perspective, what I like about this policy is that it focuses on the board, and it seems to me that the board is the one engaging in legal counsel, and the board engages the legal counsel. The board then has controlling rights over that legal counsel, and so I think that I understand there was some conflict. There was a disagreement or conflict, whatever it was, between self and Trustee McGuire and other Trustee Burt or others. In December, and I think that's unfortunate, and I hope that doesn't happen in the future. But I think what this policy does, from my perspective, is returns all this. It makes it clear that ultimately it's the board that has this authority, and the board not trying to delegate to one certain individual, but it's ultimately the board. So four members of the board. Constituting a majority. So therefore, I look forward to supporting this policy tonight.
Thank you. Anyone have any other discussion? Secretary Napolitano, please call the roll.
Trustee Bernstein,
Yes.
Trustee Wozniak,
Yes.
Trustee Olson,
Yes.
Trustee Napolitano is yes, Trustee McGuire,
No.
Trustee Mazzocchi,
Yes.
Student Trustee Rourke,
Yes.
Motion passes. Given the lateness of the hour, would any